Stephen Warner, folks, on the Barton organ with Perry Mason theme. Fantastic. Hopefully, I noticed you guys were clapping for some of those, so I know a lot of you were paying attention, and I love that. Welcome to the Penny Stamps Distinguished Speaker Series. My name's Christina Hamilton. I'm the series director. And yes, folks, we've almost made it through January. We're doing very, very well. So good on all of us. We opened this season just a few weeks ago with Oscar Eustis offering us thoughts about actions of theater and democracy, and now we move into the inner workings of where democracy takes place in the courtroom. Today we present a conversation on the theater of justice to explore the work of the courts and the law and how the human impulse for narrative performance and drama informs the inner workings of the courtroom and how the courtroom itself is then represented theatrically on stage and screen. And to do this, we have brought together three very special guests: Michigan Supreme Court Chief Justice Bridget McCormack, fans in the house. We also have legal scholar, professor, and practitioner Len Neehoff, and flown in from afar, acclaimed actor and writer John de Lancie. Ooh, fans in the house. So today's event is presented in partnership with the University of Michigan Museum of Art, as this event here is heralding the coming of Witness Lab, which is a project by Roman Witt artist in residence Courtney Mcclelland, who's an artist and writer who is currently in residence here this semester, and will be mounting the Witness Lab project at UMA, or the University of Michigan Museum of Art, in the Sten Gallery, which is the glass gallery on the front of the museum, in just 2 weeks' time. So what is Witness Lab? Witness Lab is a museum-based courtroom being created by Courtney Mcclelland as an installation, performance site, and workspace. So yes, she's turning the Sten Gallery into a real-life replica of a courtroom, which will serve as a venue for mock trials, staged readings, reenactments, classes, and other performances. So through the creative interventions, Witness Lab is itself a performance project which will unfold over time. It opens in February, it runs through May, and offers the public a complex truth. The relationship between performance and law is itself a living, evolving, and interpretive act. So opening in February, you can see all kinds of different highlights, performances. Some community high school kids and Huron High kids are gonna have their mock trial teams there. University Theater Department folks are doing some Shakespeare and Brecht courtroom scenes in February. Two of our guests today are also, Len and Bridget both are having classes in the courtroom, which you won't wanna miss. So all of these events you will be able to find on the University of Michigan Museum of Art website. And yes, if you want to get involved in another way besides as a witness or viewer of Witness Lab, you still can. If you want to get on the schedule, you have a fantastic idea for the courtroom, you can do this. You need to get a hold of the artist herself directly, Courtney Mcclelland. That is McClelland ending in N, there is no D. And her email is Courtney with an EY, L for the middle letter, McClelland @gmail.com. If you can't remember, you can email me and I will connect you. Next week, please do remember, we have two events next week. We have a special event here on Tuesday that you will not want to miss. We are hosting Jim Jarmusch and his producer Carter Logan here on stage, and that will be Tuesday at 7 p.m. So not 5:10, not Thursday, but Tuesday, 7 p.m. Jim Jarmusch will be here with his band Squirrel, and they'll play some music, and we'll be doing some talking too. And then again on Thursday next week, we will have our regular event with Angela Washko. So we will have a Q&A today at the end of the conversation on stage. You'll notice it's going to be in here. There are microphones on stands at the end of the two aisles here. So if you have a question, come on up, get in line, and you can ask it. So we have these three important folks here today. I am going to give you just the very briefest few words as introduction to each of them, because each one of their CVs or IMDb's respectively are just massive. So here are just the very pertinent basics for you. Chief Justice Bridget McCormack. She joined the Michigan Supreme Court in January 2013. She became Chief Justice in January 2019. And as Chief Justice, she's promoted statewide initiatives devoted to improving court services to the public, and in particular, delivering on a promise that the courts are independent, accessible, engaged with their communities, and efficient. John de Lancie is best known for his role as Q on Star Trek: The Next Generation. However, his credits are very numerous, and I'm not going to name even the beginning of them all. You can look up his IMDb, it is massive. He was recently in a national tour of the Scopes Monkey trial, where he played Clarence Darrow and is the first recipient of the Clarence Darrow Award. De Lancie is currently at work on a play about the Dover School District trial, which hopefully we'll hear more about today. Len Neehoff is a nationally prominent law practitioner, professor, and scholar in the fields of media law and the First Amendment, higher education law, trial and appellate litigation, and he is working on a book about the Salem witch trials. So, to lead us off and acting as master of ceremonies or host this evening is Mr. Len Neehoff, so please welcome Mr. Len Neehoff.
Good evening and welcome. Thank you so much for being here tonight. Our theme is the theater of justice, and that invites lots of questions. When and how does the theater come into the courtroom? When and how and why does the courtroom go into the theater or into movies? What roles do people play, and why do they play them? And are they playing themselves or a different role or both sometimes? And of course, sometimes most intriguingly, what happens backstage? Many years ago, I had the opportunity to hear Nobel Prize laureate Elie Wiesel give a speech, and when he came to the conclusion and the question and answer period, he said, "Here's how this works. You ask me a question, and I tell you a story." So to get things started, we're going to tell some stories. And we're going to begin here. You are no longer, as of this moment, in the beautiful Michigan Theater in Ann Arbor, Michigan. You are instead in Dayton, Tennessee in 1925. School teacher John T. Scopes has been charged with violating a Tennessee statute that makes it unlawful to teach evolution in any state-funded school. Scopes is being prosecuted, and he's being represented and defended by, at the time, probably the most famous lawyer in the world, Clarence Darrow, who coincidentally happened to attend the University of Michigan Law School. Go Blue. You are no longer whoever you are. You are now members of the jury, and Clarence Darrow is about to address you. Will you please welcome John de Lancie?
I thought you might enjoy hearing this because keep in mind that the Butler Act, which is what Darrow is going to be arguing against right now, the Butler Act said that it shall be unlawful to teach any theory that denies the story of evolution and creation, I should say, as told in the Bible. Now, what I'm about to say, Your Honor, is that to impose on a science course a particular view of creation from the Bible is, in our view, interfering with civil rights. Your Honor, I am going to argue this law as if it were serious and as if it were a death struggle between two civilizations. What we find here today is as brazen and as bold an attempt to destroy learning as was ever made in the Middle Ages. The only difference is that we've not provided that Mr. Scopes should be burned at the stake. But there's time for that, Your Honor. We have to approach these things gradually. Now, we have been informed that the legislature has the right to prescribe study in the public schools. Within reason, they no doubt have. But the people of Tennessee adopted a piece of legislation that says you shan't teach any theory on the origin of man except the divine account contained in the Bible. No legislature is strong enough to pick any book as being divine. The state of Tennessee has no more right to teach the Bible as the divine book than that the Quran is one, or the Book of Mormons, or the Book of Confucius, or the Buddha, or the essays of Emerson, or any one of 1,000 books to which the human soul has gone for consolation. Now I ask you, what is the Bible? The Bible is made up of 66 books written over a period of about 1,000 years, some of them very early and some of them comparatively late. It is a book primarily of religion and morals. It is not a book of science, never was and never was meant to be. There is nothing prescribed that would tell you how to build a railroad or a steamboat or how to make anything that would advance civilization. It is not a book on biology. They knew nothing about it. They thought the earth was created 4,004 years before the Christian era. We know better. I doubt if there's a person in Tennessee who doesn't know better. And there are in America at least 500 different sects or churches, all of which quarrel with each other on the importance or non-importance of certain things or the construction of certain passages. So who is the chief mogul who will tell us what the Bible means? No criminal statute can rest that way, and the Butler Act is a criminal statute, and every criminal statute must be plain and simple. My friend, the Attorney General, says John Scopes knows what he's here for. Yes, I know what he's here for. He's here because the fundamentalists are after anyone who thinks. He's here because of ignorance and bigotry are rampant. I'm interested in science, and I believe in evolution. Mr. Bryan neither knows nor cares what science is, except to grab it by the throat and throttle it to death. Now, as anyone interested in science, can a legislative body say to somebody like me, you cannot teach a book or take a lesson or make a talk on science until you first find out if you're saying anything against creation? Your Honor, the Butler Act makes the Bible the yardstick to measure every man's intellect, to measure every man's intelligence, to measure every man's learning. Is your mathematics good? Turn to 1 Elijah. Is your astronomy good? See Genesis chapter 2, verse 7. Is your chemistry good? See Deuteronomy 3:6, or anything that'll tell you something about brimstone. Every bit of knowledge that the mind has must be submitted to a religious test, and that is a travesty of justice and the Constitution. Your Honor, if you today can take a thing like evolution and make it a crime to teach it in the public schools, tomorrow you can make it a crime to teach it in the private schools, and then in the hustings or in church. At the next session, you can ban books and newspapers. If you can do one, you can do the other. And after a while, Your Honor, it's the setting of man against man and creed against creed, until with flying banners and beating drums, we are marching backwards to the 16th century, when bigots burned the men who dared to bring any intelligence, enlightenment, or culture to the human mind.
If someone is officially in charge of 1/3 of our state government, you can be sure they have a story to tell. To share one that can be shared, please join me in welcoming our Chief Justice, Bridget Mary McCormack.
If someone could figure out who agreed to let me follow a professional actor on stage, I would like to fire that person. I'm going to tell you a story about some University of Michigan law students and a hitman's mother. In 2001, a man named Renee Hunter was murdered in the northwest corner of Detroit, the corner of Pembroke and Greenfield, in broad daylight. He was pushed out of a car and shot multiple times on the sidewalk. There were at least 2 men in the car, and there were lots of witnesses. It was the middle of the day. 8 of them gave statements to the police. They all described about the same thing. They saw him pushed out of a car that was described as a gray or light blue Chevy Caprice Classic. One of those witnesses was an off-duty police officer. One of them saw 3 numbers in the license plate, 7, 3, and 4. 3 months went by and the police had no suspects. But they did have a man in custody who was aptly named Larry Wiley. Mr. Wiley was accused of a series of B&Es, breaking and enterings, and he did not want to stay in jail. So he told the police he could help them solve the Renee Hunter murder. He knew who did it. It was the Provience brothers, Dwayne Provience and his brother Dial. And they pushed Mr. Hunter out of their gold Buick Regal and went on their way. Mr. Wiley was released. He showed up for trial. The Provience brothers were arrested. They were tried. And the only witness to testify at their trial was Larry Wiley. Dwayne Provience's lawyer did not call any of those 8 scene witnesses. That lawyer was later disbarred for something else. He did not call a single one of those witnesses. His brother, Dial, waived a jury, and the judge acquitted him because the judge did not believe Larry Wiley. But the jury convicted Dwayne Provience, and he was sentenced to up to 70 years in prison. He had 3 kids. Fast forward now, 7 years, and the University of Michigan Law School opened an innocence clinic where students investigated claims of wrongful conviction. We got a letter from Dwayne Provience. He had an affidavit from Larry Wiley admitting that he had made up that story and that that never happened. So we sent the students out to investigate. They first had to find Larry Wiley. That was actually a lot of work. They understood that he was often on and off ramps asking for money in highways in Detroit. So students drove on and off a lot of highways in Detroit asking people if they were Larry Wiley. They once actually asked Larry Wiley if he was Larry Wiley, and he said no. But eventually he fessed up. They brought him to Ann Arbor, and in a mock trial courtroom at the University of Michigan Law School, he told them that, in fact, he had not been at the corner of Pembroke and Greenfield that day. He made it up. He was told that he would be released from custody. He was released from custody, and he wanted to make it right. That was not going to be enough to change the outcome for Dwayne Provience, so we sent the students out to the neighborhood to see what else they could find. And that's when they found Sabrina Irving, whose son had also been murdered around the same time that Renee Hunter was murdered, in fact, 2 weeks later. And she believed that the person who killed her son, that his testimony at the trial was that he was hired to kill her son because he was about to tell the police who had killed Renee Hunter. So they killed him so he couldn't talk to the police. The students then found the transcript of the trial of Sabrina Irving's son's murder. And the person who was convicted, in fact, that was the story. The police and the prosecutor at the trial said that he was killed because he was about to tell the police that the Mosley brothers killed Renee Hunter. Same courthouse, same prosecutor's office, argued to a jury that somebody else killed Renee Hunter than the person they had convicted and was serving a long sentence in prison. Still not quite enough. This is helpful, we're getting there, but we needed even more. We know that when you go to court to try and prove somebody who's already been convicted is not guilty, you need more than that. That's when they had to find the hitman's mother, because they hoped that she would have some police reports from that case that might be relevant to ours, and she did. And in those police reports, it became clear that the suspects very early on were the Mosleys. That led us to figure out what kind of car the Mosleys drove in 2001. And sure enough, they drove a gray Chevy Caprice Classic, and we were able to pull the license plate, and it had the numbers 7, 3, and 4. Dwayne Proviance walked out of prison in 2009. The mother of his children told me that every single Mother's Day, every single birthday, he sent all of the money he made the entire time he served those years in prison. That before he went to prison, he walked his children to school every day. I think I'm going to end the story right there. How do you feel about that? That's it. That's my story.
I've got a story too. John Hazenleder was 16 years old, lived with his divorced mother in Macomb County, Michigan. John came home from school one day and he wasn't feeling well. Went into his bedroom to lay down, and a little while later his mother came in to check on him, and she found a boy she could barely recognize. He was twitching, thrashing, his eyes had sort of rolled back into his head. He was quasi-comatose, non-communicative. She called 911 and an ambulance was sent, and the ambulance drivers took one look at this 16-year-old boy with long hair and said, he's on drugs. And they took him to a local community hospital on New Year's Eve, where an ear, nose, and throat doctor was one of the two presiding physicians. When John came in, the doctors who looked at him thought it's probably true. He was convicted, had been taking drugs and was suffering from a drug overdose, and they started to treat him accordingly. It turned out that John was not on drugs. John was suffering from something called Reye's syndrome that happens with children and teenagers when you give them aspirin when they have flu-like symptoms. If you look at the back of an aspirin bottle now, it will warn you against this. But in the early days, people didn't know that that's how Reye's syndrome occurred. 60 Minutes did a show about misdiagnosed cases of Reye's syndrome, classic public interest reporting. And the correspondent, Ed Bradley, and 60 Minutes were sued by one of the doctors who treated John Hazenleder. And the theory was that in the reporting, 60 Minutes had made the doctor look as if he had committed malpractice. Very few libel cases go to trial because the First Amendment provides so many strong defenses, but this one did go to trial, and we tried the case in Detroit in federal court. One of the issues in the case, really the central issue, was what tests the doctor who was treating John had ordered. The doctor said, I ordered all the appropriate tests, and the most important of those was a test called an SMA. We looked at the medical records of John, and sure enough, if you looked at the record, you could see SMA written in on one of the records. But there was a little bit of a problem. It was in a different color ink than everything else on the form. And it didn't look like it was in the same handwriting. So we hired a crack handwriting expert to take a look at the document, and he looked at it and he said, well, I can't do an ink analysis without destroying it, and I can't do a handwriting analysis without exemplars, so nothing like that is really going to help me figure out when this was written on this form. We were just about to give up, and he said, but there's something interesting about medical records. When you go into the hospital, and you're in your hospital bed, first person comes in, they make out a record, next person comes in, they put another record on top of it, write on it, then another record, and they write on that, and then another record. And when they take all those medical records, after you've left the hospital, either because you've left in good health or because you've passed away, and they send it down to medical records, they flip all the pieces of paper in the chart, so that if anybody goes in to look at the chart later, it's in chronological order. And our experts said, you know, sometimes if somebody writes on something, once it's in medical records, it'll leave an impression on the wrong document underneath it. And you can actually tell that it was added later because it leaves an impression on the wrong document. And this sounded very much like a television detective show. So we said, what a great theory, if only we could prove it. And he said, you know, funny thing. Turns out there's a machine called an ESDA machine, and it shows the traces of writing. And we put the documents through the ESDA machine, and we had him. It had been added later. Now, the lawyer for this person had the opportunity to take the deposition of this expert, and I remember standing there when he looked at his client and said, do I need to find out what this expert is going to say? And his client said, no, because those records are as clean as the driven snow. And so it came as a surprise to them on the day of trial when we brought in screens and the ESDA machine, and we put them in front of the jury, and we showed how the document had left, how whoever had added SMA had left an impression on the wrong record, that it clearly had been added later. And I had the privilege of examining the expert witness who was going to testify to all of this. And the last question I asked him was, I said, Mr. Spakeen, in your professional opinion, were these documents altered? Were these letters added after John Hazenleder died? And as I finished the question, I looked over at the jury, and every single juror looked at me and went, and that's when I knew we were in pretty good shape. Well, welcome again. Thank you so much for being here. I was trying to figure out who should get the first question when you have so much talent on stage, and I resolved the issue by realizing that John could not hold me in contempt. So I'm going to start with Bridget. And Bridget, Christina gave a very quick sketch of your current role, but I'm wondering if you could just share with people a little bit about your background, because you've done so many different things and you've been in so many different theaters of justice, and it's an interesting story. So if you could just give them some background.
Absolutely. Thank you for the question. I started my legal career as a public defender in New York City, representing hundreds, thousands of clients accused of crimes who couldn't afford a lawyer. I worked for the Legal Aid Society. I went from there to the Office of the Appellate Defender, arguing appeals for indigent criminal defendants, which is a great way to, get elected to office later, represent lots and lots of people accused of crimes. It's super popular. And then I started teaching. I taught for 2 years at the Yale Law School in their clinical programs where students represent real clients and who can't afford lawyers. And I went from there to Ann Arbor in 1998 and taught at the University of Michigan Law School until I was elected to the court in 2012 in various clinical programs as well as criminal law and some other classes, including the Michigan Innocence Clinic, where the students were able to exonerate Dwayne Proviance and have exonerated another 18 people since then, which is pretty tremendous. And then I went and ran for statewide office and got elected to the Michigan Supreme Court. So here we are.
Yeah, that's an applause line, definitely. And it was the first time you'd ever run for any office, so
yeah.
You started by aiming really high, and that was good.
Yeah, nice, just go for it.
Yeah. So is there, and now you're the Chief Justice?
Correct.
So one question people always have is, how do you become Chief Justice? Like, do you have to pick off the opposition somehow, or how does that happen?
It happens differently on different courts. On our court, it's a vote of the court. So the 7 justices choose their chief. They choose their leader.
And what is, to be the Chief Justice, what does that mean in terms of what you do on a day-to-day basis? How does that change your job?
You don't get any extra votes, still only 1. You have a lot more work. The court is, in addition to its decision-making function, which is obviously an important function, and you have to run that function, run the conferences, run the courtroom. But the court is also charged with the administrative oversight of the courts of the state. All of the courts, there are 242 trial courts in Michigan. They hear about 4 million cases a year. What happens in those trial courts is actually what matters most to the people of the state. Not very many people come to the Michigan Supreme Court, but a lot of people have important business in their local trial courts, whether it's a criminal case or a family law case or an eviction. A lot of important things happen in those courtrooms, and the kind of justice we deliver in those courtrooms is, I think, the most important part of the job. So I spend a lot of time on that part, supporting the trial courts and the work that they do.
On the administrative pieces. And
Yep.
so we're going to return later to some of the initiatives that the court has and that they're pushing now. And so I want to, some very important access to justice issues and things like that. So we're going to return to that. But I want to, John, get a little background from you also. So where are you from originally? Where were you born?
I was born in Philadelphia.
And how did you end up in the theater? Did you have theater parents, or what led you there?
As we talked before, I went to a very little school, a tiny little school in Philadelphia, mostly because I flunked out of just about every place that I had been in before. By the 6th grade, I actually flunked that grade, which I understand they don't do anymore. But and the reason was that I was flunking so much is that I didn't know how to read, and this was just before the whole issue of learning disabilities and also dyslexia. So they would simply say that your son, John, is lazy, slow, mildly retarded, and I would just continue to flunk. And I was very fortunate in the last school in which I went to, it was a tiny little school. We had a marvelous teacher, and he would, in a classroom of my senior class was 19 kids. He would come in and he would say, we're going to do Henry V, we're going to do Marriage of Figaro, we're going to do whatever. And in this case, it was springtime, and he said, we're going to do Henry V. I was about 14 years old. And I did it. I learned it. I learned how to, I played Hal, and I learned it, and with great difficulty. And I was very fortunate in that one of the grandfathers who had come to see his granddaughter was the editor of the Pelican Shakespeares. And he took my father aside and he said, if your son has an interest, you might encourage him because he seems to have a flair for this. And I just grabbed onto that like it was a life preserver, and here I am many years later.
When you say this initial memory, the initial learning of the part and this initial experience was so hard, was that hard because it was related to the dyslexia, or just hard because it was unfamiliar? Or what?
Well, it was hard to read it. It was hard to read Shakespeare. It was hard to read. It was hard. I didn't know how to learn. I didn't know how you learned lines. Years later, I ended up going to Juilliard and what have you, so clearly something was working. But I had a teacher once at Juilliard said, you have a strange relationship with words. And it's really sort of, what's perhaps even stranger is that I've made my life with words. I write a lot, I deal with words a lot, and yet I guess I do have kind of a strange relationship with words.
So one of the, I don't know if you could hear this or not when you were off stage, but when Christina mentioned the role of Q, there was some applauding and hooting and cheering. And
Q?
Yes. Yeah, you can look it up.
What about R and P?
Well,
you don't want to talk
go.
about those?
And I'm sure for many people, that's the role they
Right.
most prominently associate you with. But what are some of the other roles that you've played over the years? Are there some that have a special place in your heart or in your thoughts?
Yes, one of the things which is really fun about acting is that we're very project-oriented, not unlike what you were saying as an attorney when you are actually trying a case. That becomes your world. Well, when we do a play, and the reason I'm mostly talking about plays is because you spend a great deal of time on a play, as opposed to a movie or a television show, which you might prepare for and what have you, but you don't spend anywhere that amount of time. So you learn a lot. And it's like going into a history course, and then you're also trying to understand a little bit about the person in which you're playing, and you are empathizing with them, and you're learning a lot along the way. So one of the characters in which I played, which meant a great deal to me, was Raoul Amundsen, who was the explorer who went to the South Pole. Just his way of getting there. He was right at the edge of that sort of noble, romantic idea of exploration, and then the professional. There's, by the way, a great podcast that uses this phrase. The British were, he got there before Scott. And one of the ways in which he got there, Scott took with him, tons of supplies. It was like, a safari, except over ice. And he went almost solo. And on the way back, food-wise, he ate the dogs. He was a pro. And you talk about with Q. I was actually doing that role when I got called to audition for Star Trek, and I did not show up at that first audition. I said, I'm in rehearsal. I'm doing a play. I'm not going to rehearsal. And they called me back. They said, listen, they want you. It's a week later. And I went, okay. So I had all of that up in RAM. I was, like that. So I just walked in, boom, like that, and that was it. So,
one of the great things about the Stamp series is you always learn something. And I'd never really thought of being a pro as being defined as that you eat your dogs.
You eat the dog.
This is a new
right.
concept for me.
That's
so
right.
I have to apply that more broadly. So there's, and you've got this project that I know is near and dear to your heart that you're working on now, that in some ways conceptually is kind of close to the Scopes trial issues. It's related to the Dover case.
Yes, I'm working.
I
I just finished a new piece about the 2005 Dover Intelligent Design trial, and actually Ann Arbor has a connection in that the Thomas More Law Center, the Sword and Shield for People of Faith, were the people who defended the intelligent design. Intelligent design, for those of you who don't know, is just a complete sham. And it was a way to get creationism into the school system. And this took place in Dover, Pennsylvania, when the school system was taken over by fundamentalists who then threw out the science book and brought intelligent design in. So I think it's an important trial. Having Ed Asner and I went around the country, not just recently, but a number of years ago, doing the Scopes monkey trial, and this took place in 2005. The Dover Intelligent Design, and some people call it the Panda trial, because the book, the Intelligent Design book, is called Of Pandas and People.
And it's a really interesting case also because the judge actually ends up playing a sort of significant role in the proceedings.
Tremendously significant.
Sometimes Justice Roberts, what's the famous line about we're supposed to be umpires and nobody comes to, watch us play and so forth and so on. Although right now everybody's kind of watching. But he was very active in the trial, I think, and I think threatened to pursue perjury against some people.
Yes, I mean, what happened is that, and as he says it's really a shame that people who carry on as much as they do about their moral standards are the ones who were lying as much during the trial. He got so upset. If you read the testimony, it's very dramatic. It's very dramatic testimony where, of course, you have the two lawyers and what have you, and two of these defendants are lying so much that he goes, hair on fire. Excuse me, I'm going to take over the questioning for a moment, and then begins to question the defendant and reminding him, you are under oath. Do you understand what that means? Do you understand what that means? Again, I found it interesting because of the separation of church and state issues. I found it interesting because it's a continuation of the Scopes trial, which you kind of go, well, excuse me, it's been like almost 100 years. And I found it interesting because of the lying, because of the willingness to just to lie. I mean, there's in one of the instances, the attorney takes him through. Now, you never said the word creation. No, I never said that. And you never said it in this case and during the school board. Nope, never said it, never that. And you never said it in front of any reporters. No, absolutely not. I would never have done such a thing. Boom, comes the video, and the guy's saying, yeah, we need to get, we need balance. We need to get this evolution theory stuff taken care of, and we got to put creationism. Yeah. He goes, do you have anything to say? And he goes, well, that's been doctored. Kind of go, wow. So I think it's really relevant now. Yeah.
I was going to say, this all seems so unreal.
Yes, sadly.
There's gambling in Casablanca, too.
I'm shocked.
I'm shocked.
Right.
One of the interesting things about the case, too, if I'm remembering this correctly, is that after the judge rules, and the judge really upbraided the school board and the people who testified, and somewhere, if I got this right, after he issues the opinion, he says, I know what's going to happen, which is tomorrow somebody's going to say, oh, look at what this activist judge did. And I think in the press the very next day, that's pretty much what certain media outlets have reported was
we were talking about
judge.
that. We were talking about that. And one of the things in which he said, I am, if you think that you've come to an activist judge, forget it. It's an activist school board with an activist attorney, Thomas Moore, who brought me this case. I'm not an activist judge. Yeah.
So Bridget, you told one story from the Innocence Clinic sort of theater of justice that you were in, but I know from many conversations that we've had that you have lots of stories from your work as a legal aid lawyer and as a public defender. Any of those stories come to mind where you thought as it was unfolding, boy, this would make great theater, or this is great theater? Can you share a story?
The thing about being a public defender is that happens almost every day, and it's hard to choose. I mean, but I'll tell you, I was once waiting for a verdict. I had a jury out, and so the judge was going to start picking a jury for his next trial, and Bill Kunstler, the famous civil rights lawyer, was the lawyer in the case following mine. So he was actually in the courtroom when I gave my closing argument. My jury was charged and sent to deliberate. And then he was going to be picking a jury. And so we had a lot of time together over the course of the day that I was waiting and while he was picking a jury. And he did something in picking in picking a jury that could never have imagined doing myself. And don't know if anybody else could only Bill Kunstler could pull it off. But so the court brings about 100 potential jurors to the courtroom. That's about the number to get a jury of 12. And the judge puts 12 jurors in the box, and the rest have to wait because as they get picked off, they take their seats. But Bill Kunstler is addressing the whole room of them all, these 100 citizens there to serve their government. And he says, it's really, really hard to vote not guilty in a criminal case. Police believe this person's guilty. The police believe my client's guilty. They arrested him. They put all this time into it. The prosecutor believes he's guilty. He's put all this time in it. He's here. He's gonna spend all this time in this trial, these resources. It is really hard to vote not guilty. And so I think we all should practice it. We should do it. We should feel it. And he says, on my count, I want us all to stand and say the words, not guilty. And I swear they all did it. I mean, the judge might have stood and said it. I did. I was like, he's like, 1, 2, 3, and everybody's like, not guilty. It was tremendous. I mean, it was wonderful.
It's also an art to know, like, you just got away with something and so don't push it. So like I would have been tempted to say, okay, now everybody stand up and say, give us an eye,
Yeah.
right? Sort of see how far you could take that. You were really happy as a legal aid, as a public defender, right? I think you
I
might
was, yeah.
still be doing that. Why
It's
did
the best
you,
job in the world.
Why did you stop doing it?
I was fired.
We're seeing a pattern here of sort of promising failure.
Yeah. No, it's a little more complicated than that because we were all fired. So the Legal Aid Society was, the staff lawyers were in a union, and we voted to go on strike in 1994 for our clients. I mean, we were actually striking for what would have given them better services, lower caseloads, vertical representation, things that mattered. We thought. And on the second day on the picket line, the mayor of the city of New York canceled the entire contract of the Legal Aid Society. So he fired all of us. So I wasn't really special. I mean, I didn't really, but we all were fired. And so I found myself having to go get another job.
That would have been Mayor Giuliani?
It was a man named Rudy Giuliani.
Okay.
He seems nice.
Yeah. He seems nice.
There's a
Yeah, by all means.
there's a podcast, I think, that NPR just did about how underfunded that part of the legal system is.
Oh, don't even get me started. Yeah. This is a whole other lecture. Yeah. No, of course, and that's why we have, people serving long sentences who are not guilty, and that's a problem because the real people who are guilty are still out there, and you know what? They're usually committing more crimes.
Right.
So it's getting someone exonerated is wonderful, but it would be better to get this right at the front end of the process, not the back end.
And the problem is mostly funding, or
Okay, so we know a lot about what goes wrong in wrongful conviction cases now because the DNA has actually given us a wonderful database to be able to study what kinds of things go wrong when people are wrongfully convicted. And we see the same things over and over again. Eyewitness testimony often leads to wrongful conviction, false confessions, bad science, bad forensic science leads to wrongful convictions. A lot of snitch testimony, like Larry Wiley's testimony, leads to wrongful convictions. But the single reason that people are most likely to be wrongfully convicted is ineffective assistance of counsel, bad lawyers. And it's not, and
is
underfunded.
it bad lawyers, or is it that their caseload
underfunded? Yeah, I mean, it's I don't want to be too critical of a lawyer who's trying to manage a caseload that just doesn't allow her to put in the kind of hours that you would need to do the investigation to get it right at the front end. I mean, in Dwayne Proviance's case, maybe just call those witnesses. It doesn't seem like that much work, but in many cases, underfunding and overworked lawyers have a harder time getting it right at the front end. Yeah.
When you were talking about Kitzmiller's performance and the things that lawyers, to return to the sort of the theater of the courtroom theme, the things that sort of well-known lawyers can get away with. When I was a very new lawyer, I was in court one day with a wonderful trial lawyer who was sort of a mentor named Bill Saxton. And Bill had made an argument in front of a judge, and the judge ruled against him. And the judge got up to leave the bench. She was a relatively new appointee to the bench. And Bill said, "Your Honor, may I have your attention for just one moment?" And you never do this. Once the judge has ruled, you just close your briefcase and leave. But he stopped her, and she turned and said, "Yes, Mr. Saxton." He said, "Your Honor, I've never done this. I've never argued with a ruling. When the court has ruled, that's fine. But you just made a mistake, a terrible mistake. And you will know that you made a mistake if you just read one sentence in one statute. And I would ask you, please, to go back to your chambers, read this one sentence in this one statute. And if you conclude that I'm wrong, if you conclude that you were right, you can come out and hold me in contempt." And I'm sitting there looking up at him thinking, I'm an associate. I don't have bail money. I don't know how this is going to work. And she looked at him, and to her credit, she said, "Okay." And she went back and she read the statute, and she came out and she said, "He's right. I made a mistake," reversed her ruling. The other side almost fell over. And I looked at Bill and I said, "That's the most brilliant thing I've ever seen." And he smiled at me and he said, don't ever do that. And of course he was right. He could do that, but me, not so much.
Did you see? I'm interrupting your questions, and I apologize. But I heard this transcript, audio recording of an unbelievably dramatic thing that your story reminded me of in the Third Circuit Federal Court of Appeals that just happened last week or the week before. It's a death penalty case. The district court judge, the trial judge, has granted the defendant a writ of habeas corpus because of a legal error that happened in the proceeding that made a difference in the outcome. But it's a death penalty case. The guy is they're gonna have to retry him. And so the prosecutor appeals to the Third Circuit, the appellate court that hears it. And the panel comes out, you hear the audio, and they say, we understand you have something to tell us. The prosecutor's the appellant, so he's gonna go first. And he's the elected prosecutor in some small county. It's not Larry Krasner. It's like just an elected prosecutor in some small county. And he says, as I was preparing for the case, I was, over the last few days, I got less and less comfortable with my legal position. And I no longer believe that it's correct for us to be appealing this ruling. The defendant deserves a new trial. And the panel sort of was stunned and said, well, will you excuse us for a minute? And they left the bench. And then they came back and they thanked him and told him how, what a breath of fresh air it was for him to come in and concede error. It's it's very short, but unbelievably dramatic thing to happen in an appellate courtroom, which almost never, it's usually dramatic things happen in trial courtrooms. This is appellate drama.
And also dramatic because it's something you so rarely see, so unexpected. And one of the interesting things about this, of course, is that prosecutors actually have as their client justice.
Correct.
Right? I'm trying to, in the civil system, there's an old joke about the lawyer who sends an email to his client and says justice was done, and the client says appeal immediately. In the civil system, you represent a client, and the criminal defense lawyers represent a client, and so trying to get a client to that space, right? We have to give up. That's a different dynamic. But this is, I think, isn't this a dynamic that should actually happen more often?
It should, and maybe it will. I have to say, part of what was interesting about it was that it was the elected prosecutor, right? Mm-hmm. It's somebody who 10 years ago would have been worried about taking that position in his next election. And I feel like there's a little bit of a shift in public opinion about what we want out of our criminal justice system. And I don't know, I found it pretty incredible.
And what you're saying we want is being honest?
Well, yes.
Yeah.
A.
Telling the truth?
B.
Now you're really stretching.
What else do you want? Yeah.
I'm just thinking of having watched CNN this morning, so I'm just taking it from...
You went to the wrong well, I think. We're talking about, John, on this theme of famous lawyers. So Clarence Darrow is, for lawyers, this towering figure. He's involved in all of these incredibly famous cases, including the Sweet case that comes out of Detroit, the Leopold and Loeb murder case. And so here's this sort of towering figure. How did you go about trying to get your head into his head? What interested you about the figure, and how did you start to learn more about him?
In the case of a trial, where what we did was we followed the trial transcripts. It's very word-oriented. So we're not, you're playing a character, but it's not really what the issue is about. And unlike the, what is that movie? Inherit the Wind, nobody cares about whether John Scopes' his girlfriend or, nobody, we're not talking, there's no love story or anything else. It's like following the bouncing ball. And so the issue is, can we make this trial work? Especially in the case of the Scopes trial, where the judge was absolutely not interested in any of the evidence. It was very simple. In the case of the Scopes trial, did John Scopes teach evolution? The irony is that John Scopes was not the science teacher. John Scopes was the athletic coach. And he was a substitute teacher for that day, using the book, the science book, Hunter's Biology, by the way, that was purchased by the school board, okay? And the chapter was, okay, kids, what chapter are we on today? It's, chapter 9, okay, evolution. That's, and I don't know if you all know this. I know they know it. And this was a publicity stunt. The Scopes trial started out as a publicity stunt. Dayton, Tennessee had lost its single biggest employer about 7 years before. I think it was a foundry. So a lot of people went out of business, or there was no more work. And in Robinson's drugstore, they happened to be reading the newspaper, and there was a want ad, I guess you call it, from the ACLU saying that we want to have a test trial for the Butler Act, which is what you heard a little bit. And they said, oh, that would be really good for our little town. Gee, and we have a courthouse right across the street. I mean,
Let's put on a show.
Let's put on a show. So that's truly what it was.
A law show.
Yeah, and the ACLU was not interested in having Darrow involved at all. They were doing business. They weren't doing a circus. They were doing business. So, but when William Jennings Bryan said, "Oh well, I will defend. I will be involved in this," then Darrow said, "Well, when I heard that Bryan is going to do it, I'm going to do it." And these are two guys that have been going around the country for years arguing their points of view. One of the things in which I found to be the most interesting in all of this, and you asked me about creating a character, for which I'm sort of not answering you, but is that the way in which people talked back then, the ability to get up and speak extemporaneously for long periods of time, and really beautifully, Darrow, Bryan, and Malone give 3 speeches in there that are exquisite. And we don't see that. We don't see that language being used anymore. I was asking you, do you see it in the courtroom anymore? And you don't really do it. So there are a lot of things that I found to be interesting about it. And because there was so much textual work having to be done, and the issue is the audience, today's audience, going to follow this? Follow what's going on, where the judge is essentially saying, objection, objection, I don't want to hear that, I don't want to hear that. And these guys are trying to get in their points and what have you. That became sort of the interest for me.
So to circle back to what you were saying earlier, it's almost sounds to me like what you really fell in love with here was the language, that it was the words almost more than the character of Darrow himself.
Yes, I mean, yes.
Good. Now, see, eventually the lawyer will get you to answer the question.
That's right.
That's how.
All of a sudden, I felt like I was at a deposition.
Yeah, that's right. That's right. And now will you answer my question? Yeah. So it's it's so true. There's a passage in Clarence Darrow's argument in the Leopold and Loeb case I was mentioning to you earlier, where Darrow is trying to persuade this judge not to order their execution, but to order them to go to prison. And he's got to try to figure out how to get this judge's head into the heads of his clients, to empathize with them. And there's a couple of pages that are just absolutely brilliant. And it's driven by the language, and driven by a real understanding of human nature, and being able to say, frankly, you might just think of these young men as monsters, but how close are we all, really, to making horrible mistakes all the time, especially when we're their age. Bridget, some people in the audience might not know this, but you do have a theatrical family to some degree. Will is a an actor and screenwriter and filmmaker, and Mary has lots of screen credits. Do you think being around, and you're the only lawyer in the family, right?
Yeah, my extended family, first and only, and doesn't look like anybody else is interested.
First, last.
First, last, yeah, yep.
So do you feel like coming out of that kind of milieu, that kind of family, helps at all in what you do, that it's made you more comfortable with the theater of the courtroom, made you a more comfortable public speaker, or was that just an entirely separate route and an entirely separate path?
I don't know, that's a good question. I mean, I was the oldest, which is why, I'm the responsible career person, and they're artists. Although I guess it's, I was, well, hear the end of my story. I mean, I'm a legal aid lawyer living with my sister in New York City, and she gets a job playing a legal aid lawyer on a TV show where she makes my annual salary every week. So, and then my brother was like, he was 5 years younger than her. He's like, I think I'm gonna go that way, right? She figured this one out. But I think my family is full of storytellers. My brother and sister are hilarious and like to tell stories, and I think lawyers do that too. I mean, I do that less now as a judge, really, than I did when I was a lawyer trying cases.
Although when you write an opinion, you've still got to tell a story, right? There's still going to be a narrative that goes in the opinion.
I love writing opinions, and I like to write them well. I hope, and I hope I do that. But nobody reads them,
I do.
Well, thank you. Yeah.
Thank you very much. Actually, I wrote an article once that Bridget cited in an opinion of hers, and I was so excited. Wow, I wrote this article, and Bridget cited it in a Supreme Court opinion, and then a friend of mine pointed out that the sentence right before she talked about my argument was something like, prepare yourself, the next part is a bit of a sludge or something. So it was slog, bit of a slog.
I said, please, reader, please hang in here. This next part is a bit of a slog.
Yeah, that's right. Prepare to hear from a really tedious voice. It was, felt really good. I
have a question.
Yeah.
In working on this piece that I'm working on now, one of the things in which I'm working with a woman whose name is Kristen Trevor, and she has tremendous skills, reading skills, if nothing else. We began to become really conscious of strategy, and storytelling. Mm-hmm. So there was a strategy for the attorneys, and there was also a way to express that strategy through storytelling.
Right.
So I'm throwing that out there. Can you, both of you, talk to that idea?
Sure. I mean, what lawyers do really is not, when you're trying to figure out how to prepare a case, you're actually less worried about evidence and facts than you are about what your narrative is, what your story is, your version of reality. And, then in any individual case, those versions of reality that the two sides are telling can clash substantially, or they can clash just around details. But if you can't tell a good story, then I don't think you can win a case.
Yeah, I agree with that. And I think the story is the lead, and the strategy is built on the story. It's, I think, how I thought about it.
And how much of that is staying to the, how much of that is bending? We're seeing a lot of bending of truths now and stuff like that. Hopefully one is within a certain, there are guardrails that you can't go too far, or can you?
So,
what do you and your people do?
Yes.
I'm a judge.
That's right. Well, down in the trenches, the way we do things. So when I taught legal ethics, one of the things I say to my students is, there are two populations of people in the world who routinely say things that they believe not to be true. And we call one of those groups liars, and we call the other group lawyers. And the question is, what is the ethical justification for what we do? Because very often what we do entails standing up and telling the best narrative that we can come up with that's consistent with the facts that we think we have. But do we really believe that's actually what happened? Very often not, or at least a substantial part of the time not. Now, there are things we can't do. There are guardrails. You can't walk into court and have somebody perjure themselves. There's a wonderful old New Yorker cartoon where the lawyer is saying to the client, great job, just a little more perjury and we're out of the woods. You can't do that. You can't admit evidence that you know is fabricated, things along those lines. But, you know, one of the things that lawyers actually get very comfortable with is the fact that truth is actually this, it's not this thing, it's this expansive space. And you try to figure out how to work within that space in the way that's consistent with the facts that your client has that are in their favor. But
From where I sit now, you know, I often have conflicting facts that have, I sit on the state's highest court, so I'm usually deciding questions of law, but they depend on facts. And so there are often conflicting facts, and I have to figure out what the real, you know, what the facts were. To be able to make legal decisions. Yeah.
So let me put it back to you, because what you're basically asking us as representatives of this profession is, gosh, it seems to me like you're awfully comfortable with things that aren't true. But to what extent is everything that you do sort of not true? You know, you're always playing a different character, you're always in a different time, a different space.
Right.
What are your guardrails?
Well, again, to use a play, it's easier, at least for me, to think about it. There is an understanding when an audience comes and sits down with the actors. The actors have the understanding with the audience, and the audience have the understanding with the actors, that actually what is happening is not true. It's not real. The only thing that's real is the emotion that the audience might feel, an individual might feel, when they see something, it elicits them to feel something, and that's real. But I'm not really, whatever, you know, Lord Byron. I am, or Q, or any of those other characters. And they know that. And there's nothing that we do that is anything more than to bring, sort of using Shakespeare's terms, the mirror up to nature. We do these things so that you can see yourselves, see ourselves.
But isn't your job to get them to forget that? I mean, they know that, but for them to be sort of integrated into the theatrical experience with you, don't they sort of have to forget that? The same thing plays out in a trial, right? The jurors are sitting there and they know this lawyer over here is sort of the mouthpiece for such and such a party, but the lawyer's job is to get them to forget that, to get them to think that what the lawyer is just sort of there in the interests of justice and in the interests of doing good. I mean, isn't there some similarity in this respect, that what we both actually do is try to persuade people that we're not doing the very thing that we're doing?
Yes, except the thing is,
you can just answer a different question if you want.
I'm not.
If you're like, I don't even, yeah, you can just answer a different question if you want.
That's right. That's right.
You can just say whatever you want. It's not,
This is
Put a
not the
question back to him.
This is not the Senate.
That's right. That's right. That's right. It was not a quid pro quo. It was, we're not trying to elicit the same thing. I'm not working in the world of. I'm wanting you to think. Okay, I'm not trying to get a decisive action out of it, a decision out of it. I don't know if that.
Yeah, sure. The consequences. The consequences are dramatically different.
Are very different. Also, the way in which we approach a role is not to look for the deception. We actually look for the truth in that character. What is this character? Oh my gosh! Well, this is somebody who who's incapable of telling the truth. This is somebody who lies with abandon. This is someone who feels that they are the most important person in the room. This is somebody, you go and you go, oh, I can play that. And then it's important for the audience to go, oh, how is this affecting me? I see it. I don't have to, I need to.
So Bridget, thinking about this, when you said, well, I'm an appellate, I'm an appellate judge, and so the theater, a lot of the theater that we're talking about happens at the trial level, right? And I assume you don't have like lots of theatrical appellate arguments where people suddenly juggle or swallow a sword or do something extravagant. Not often. And it strikes me that at trials, but you have a lot of experience with trials, that there are certain moments in trials that kind of lend themselves to drama. The classic in most movies, if we were to put a bunch of clips up here, would be the searing cross-examination where the Perry Mason moment where the person breaks down and cries and so forth and so on. Are there moments that you think are sort of uniquely open to theater?
In appellate courts, you mean?
In any court, in trial, in appellate court?
I mean, trial far more than appeal. I mean, although, every once in a while, like the argument I just described that wasn't an argument last week in the Third Circuit was quite dramatic, I think. At least it seems it was to me. But trials are often full of those moments and also full of a lot of plotting and boring moments. I mean, TV trials are much better than real life trials. They're much better to watch. But I don't try cases anymore, but I never got comfortable with the moment a jury walks back in the courtroom. And,
that's sort of a classic movie moment, right? The jury comes back and everybody's trying to figure out.
That's real drama, when you really don't know what they're going to say, right? And I myself experienced many of those dramatic moments with witnesses where things surprised you and you thought, whoa, I didn't see that coming. But
one of the things that non-lawyers often think is that cross-examination is hard and direct examination is easy. But most lawyers who try cases would tell you that actually cross-examination is much easier because you're asking very narrow questions. You usually have material to impeach the person with. When you're doing direct examination, which means you're examining somebody who's a friendly witness, so you can't use leading questions, that really is, I think, much harder. And people sometimes describe it as, you've got this friend who's drowning and all you can do is throw a life preserver in their general direction and hope they swim to it. But we think of the cross-examination as being the moment when drama happens. But the story that I told at the beginning about the case about the young man who died, we had an expert witness who was a medical expert. And we did not see this coming. We had him on direct examination, and the question was, what was the treatment for somebody who, at that time, for somebody who had Reye's syndrome? Because what happens is your brain swells. And he said, well, they actually, at the time, the treatment was to drill a hole in the top of somebody's head to relieve the pressure on the brain. And the lawyer who was doing the direct examination said, would that have saved John's life? Are you sure that would have saved John's life? And he took this deep breath and he said, it would have given him a chance. And he started to cry. And you could feel the collective goosebumps ripple across the room. It was this incredibly dramatic moment and a really genuine moment. I mean, it was completely unrehearsed. Nobody expected it. Nobody expected it to happen.
So does authenticity?
Yeah.
That's the essence of these dramatic moments? Then, I mean,
I think that's right.
The person that you talked about saying we don't have a case here, and then this person.
I think that's a great insight. That what makes for drama, really in your court or in any court, is the moment at which truth is revealed. The curtain is pulled back, and all of a sudden we know the answer. The witness who we thought was telling the truth isn't. We're given a new way to process the evidence that we have in front of us. Somebody concedes that they don't actually have an argument and they're not going to pretend that they have one. And I think that those moments are actually what make for the most dramatic dramatic moments. And I would suspect the same is true in your world.
Yeah, what I
Authenticity,
was
yeah.
having a hard time explaining is that we're trying to find authenticity.
Yeah.
That's what we're trying to do.
Right.
If we go out there to be deceptive, the audience sees it. They just go, it's they'll say, well, it's just bad acting.
Right.
So we don't live in that world. We live in the world of trying to distill this down to the essence and what is the truth. And it might be somebody who's being deceptive, but it's,
Yeah. So I have 600 more questions and 15 videotapes that we're not going to get to because we want to make sure that you have an opportunity to ask questions. So I think what we're going to do is there are mics in these aisles. I know some of you have to leave for other class commitments. Thank you for coming. But if you have questions, if you would get in line, that would be great. Please.
Two very quick questions. First off, we talked about authenticity and the crazy world we're living in. First off, to Mr. de Lancie, has Patrick Stewart asked you to be in the second season of Picard, dealing with a crazy world that's been flawed? Don't know. Okay, but I'll get my major question. Dealing with authenticity that we talked about a moment ago, in 24 hours, the very legal fabric of the United States may radically change. How do we push authenticity in this potential new environment? And I'll ask that for the entire panel.
Okay, so here's my best shot. The basic theory of the First Amendment is what we call the marketplace of ideas, that ideas clash and eventually truth emerges. But I think it turns out that the word eventually does a lot of work in that idea. Courtney, is that you? So this is our distinguished visiting artist, Courtney Mcclelland. Will you please welcome her? And you have a question.
I do have a question. First, I want to thank you all for having this conversation. I think this has been amazing and generous and hopefully sparked, I know, a lot of curiosity for me and hopefully our audience as well as future Witness Lab participants and viewers. My question is thinking about audience, and we talked a little bit about it in this relationship to authenticity, how in a courtroom you would have, or even if we're talking about appellate versus a trial court, like different audiences in each space. So you have maybe a jury, the judge, and even in a theatrical setting you might have a range of audiences coexisting in one theatrical space. How do you manage or tell an interesting story to meet all those audiences that are in one place together?
I think that's a great question. And in a courtroom, the audience matters a lot. So I think your presentation and an authentic presentation is very different to a jury than it is to a judge, than it is to a panel of judges or a panel of justices. They're really actually all very, very different audiences that require different presentations. And I think, don't you agree?
If you're standing up in a trial court, you've got the judge is one of your audiences, the jury is one of your audiences. There might be people sitting back in the pews who are the public audience. There might be media covering it that are part of the audience. Your client is absolutely part of the audience. One of the things that's interesting at the appellate level is that, and the more appellate arguments you watch, the more you realize this goes on. You would think that the audience was simply, if I'm arguing in front of Bridget's court, I'm talking to the court and the court is talking to me. But in fact, what's going on a lot of the time is the justices are talking to each other. And so one of the things that you're trying to do is you're trying also to watch what your audience is doing, to see what dynamics are going on there, to see if there are things that you should try to throw water on or try to throw fire on, because clearly conversations are going on as between the justices, and you're trying to figure out what to do with that. Ian, I'm sorry.
Yeah, just to answer that, That's probably the most important question that my side of the aisle has, is that who's listening? And then it's broken up into what is needed. And then the one that's the most creative is, what is wanted, and then what is needed. And so you start off with that, the expectation, and then you begin to look as to what it is that you can add to that so as the whole thing begins to transform.
Ian.
As a reformed theater kid who ended up being a lawyer, I suspect I'm not the only one. This has been a really wonderful conversation, but I have a question about video in the courtroom for Justice McCormack and what you think about filming and the inherent theatricality of the law coming through in that. And for Mr. de Lancie, I'd say, as someone who's pulling art out of actual court cases, have you found any utility in, there's obviously not a recording of the Scopes trial, but in some of these other cases of there being a recording, there being able to hear the voices and not just read the transcript, if that's factored into your work?
I am a huge proponent of video in courtrooms. I believe the courts belong to the public, and I believe they should be able to see what they're doing from wherever they are at any moment. So my court, yeah. My court live streams arguments, and then we park them on a YouTube channel, so even if you can't watch them live with my dad, you can watch them later, and I think you should be able to. I've taken that position publicly. I sent a letter to Congress recently when they were considering putting cameras in the federal courts. I know that there's some who worry that it will make lawyers perform for the cameras instead of for the court. I see no evidence of that. I never, or judges performing for the cameras instead of the court. I don't see any evidence of that, and I can't imagine why, even if there were some showboating lawyer or judge, that would be more important than transparency of the branch. 4 million people have their cases heard in Michigan courts every year. They have a right to know what we're doing in those courts.
For the most part, we use original scripts on everything. Nobody knows how Garrick sounded with Hamlet or anything like those originals. So we're used to reading. In this case, since we're talking about a trial, I'm used to reading testimony, but I'm also used to reading the subtext of a testimony, because all my life I've read the subtext. I'm following not only the text, but the subtext of plays and what have you. Yeah, it would be interesting to hear these, the Scopes trial, just out of kind of a little tidbit. It was the first trial that was ever recorded for radio. So that had an enormous impact on this country. People could hear, it was only 6 days, people could hear the trial going on, and that was amazing. And it'd be nice. I don't think that there are any recordings of it now, but it would be nice to hear them. Yeah.
There's a question over here.
Hi, I'm so nervous. Okay, this is for Chief Justice McCormack. So you worked as a public defender for a while. Obviously, you've been doing this for a long time, and it has to be, at least from my perspective, really frustrating to continue to work within the same system and see the same frustrating things, whatever those are for you, over and over again. So I guess if my assumption about you is true, what do you imagine alternatives, things you would want to be different, even if you don't think they're politically feasible? What do you imagine when you think of the ideal of how you want the system to operate and look like mechanistically?
Great question. I do think there is lots of room for improvement in the system, and I feel like I've spent a career working on those improvements, and I feel fortunate to be in a position right now to work on them in the most impactful way I've ever been able to before. And I think there's lots that's feasible, actually. We just have to be intentional about getting there. I just finished co-chairing a statewide bipartisan task force on Michigan's jails. Our populations in our jails have tripled over the last 30 years, and crime is at a 50-year low. We didn't know why. We didn't know who was in there because we had no statewide data. The Pew Charitable Trust staffed us. We now know why. We know who's in the jails and why, and we made 18 very innovative, aggressive policy recommendations to the legislature. And the bipartisan group of people around the table gives me lots of reason to be hopeful that the legislature will act on those proposals. And the leadership in the legislature has said it's their main priority this session. So I think working to actually get change done is the only antidote I know for an ailing system or worrying about an ailing system. The other big project that wakes me up a lot at night is worrying about all the people who can't afford lawyers in our courts, who have important things happening to them, like losing their homes, getting evicted, losing their children. I'm working on it, and I think there are some good ideas and some big ideas, and I hope to make a lot of progress on them. But I think keep working at fixing them. That's what I like to do.
Got a media question for Your Honor. When John came out and he did a soliloquy, I was captivated. What would happen if that happened in your courtroom? You know, all of a sudden, it was really nice. It was really great. It was captivating. Yeah. Would you, for example, allow it to go on, or would you clamp down, or what would you do?
A captivating performance by a lawyer, bring it on. I would allow it. Yeah. Okay. Yeah. We see some excellent lawyers in my court and some less. There's quite a variance. It's unlike the U.S. Supreme Court, where there's a real professional bar and almost everybody who appears in that court is a pro. Mm-hmm. In the Michigan Supreme Court, you get some pros and some first timers, and so you see all kinds of different performances, but every once in a while you get a real captivating performance. I was telling these guys backstage that Brian Stevenson appeared in my court a few years ago as amicus in a case. So he only had 10 minutes, and at like minute 9, I started thinking of questions I could ask him to keep him there, because I didn't want him to stop talking, because he was mesmerizing. Yeah. He was Brian Stevenson. He's like a prophet. He's like in your courtroom. It was tremendous.
Oh, thank you.
It's just to on this question. Yeah. One of the things that I think is really interesting about that is it is really captivating and it's really compelling. The question is, would it still be effective? The quality of that language, the force of the rhetoric, but there's a sophistication to that presentation. And one of the things that is really striking when you read Darrow's arguments is Darrow is making arguments to ordinary people, but the language is extraordinary. And he trusted in the fact that ordinary people would appreciate extraordinary language. And I wonder, is that still true? Or have we just become sort of cynical about it and think that we can't do that anymore, that would not be an effective argument? My sense is that a lot of...
Brian Stevenson.
Does it?
Oh, yeah.
Yeah. And I think when you see people who do it really well, if they look authentic doing it, Jerry Spence, right, could look authentic being who he was. Mm-hmm. So if you can do that authentically, then I think you would probably get away with it, and I think it would probably be really effective. But if you're playing that part and you're not being authentic, then I think it would struggle to work.
Thank you. And John, by the way, my wife adores you.
He adores you too.
Thank you. I adore your wife.
Alrighty, hi. So my one question that I had, because I had two, one was about
the book Just Mercy by Bryan Stevenson, and that one kind of got answered already. So love that book, had to study it for my senior year of honors English, and we had to go through and write a thesis statement on it, so it was pretty good. My secondary question, I guess, is during the Reye syndrome case, what do you think was the main component that led to this person's death in that, sense of the court case, or was it the paramedic who said, no, he's on drugs, or whatever that is, what kind of led to that end?
One of the things that I thought was really a shame about the case is that we've become so accustomed as a society to think that whenever something bad happens, somebody must be at fault. And actually, sometimes just bad things happen, and they're kind of not anybody's fault. And the story, as 60 Minutes told, this particular one, was not a story about who was to blame. It was a story about the fact that in the early days of Reye syndrome, people misdiagnosed this fairly routinely. And this was one of 3 vignettes that they did in the series, so on that particular program. So the sort of one of the ironies here is that when we were sued by this doctor saying, you made it look like I committed malpractice, we all kind of looked at each other like, no, we didn't. We made you look like a physician who was struggling with a really complicated situation. And,
so in fact, he did commit malpractice, right?
Well, see, what happened is, here's how it works.
I mean, did he end up becoming somebody who was he should have kept his mouth shut?
Yes.
Yes.
Because here's how it works. If you say my client made me look like I committed malpractice, and that's why I'm suing you, then you know what I'm going to do? I'm going to show that you committed malpractice. So that's just sort of how it works.
Right.
And so I think that he was actually in a better position before he sued, because people who looked at the broadcast would say, well, it doesn't look like everybody made the right decisions, but it was a complicated situation and the science was very primitive, and it wasn't anybody's fault.
So this proved that he went back after the fact and then put down whatever those initials were to cover his tracks.
The irony of it? All we proved was that somebody did it.
Yeah, okay.
We didn't actually prove he did it.
Right.
But once we proved somebody did it,
right,
the jury was so eager to believe that so prepared to believe that he was the one who had done it,
right,
that it was sort of the case after that point was over. You have a question?
So if you look at human history, you'll see that the rule of law falls somewhere in the range between an idealized goal and a useful fiction. And I'm wondering how, in an era so rife with obvious corruption, and in a situation where in the last 2 presidential administrations we've had a constitutional scholar whose appointments to the federal judiciary have been consistently blocked, followed by someone who has successfully appointed now an entire 5th of the federal judiciary under suspect circumstances. How is it that the rule of law can continue to exist when it seems like without effective enforcement, there is no rule of law? And I'm wondering how, from both a judicial and theatrical perspective, you feel about that environment and what you do in the context of that environment.
So 95% of civil cases and 95% of criminal cases are heard in state courts, not federal courts. And your state Supreme Court, in whatever state it is going to make the final decision and going to administer the rule of law in your state court system in almost every issue that matters to you, I promise you. I know we always talk about the federal courts and the different presidents' appointments to the federal courts. They don't really do much. I'm here to tell you. I'm just kidding, federal judges, you're great. I love you guys. But it's really state courts, in my view, that matter. I mean, state legislatures now as well. I think they're obviously, not that they didn't matter before, but if your state courts are high functioning, institutions and supporting the rule of law, I think that matters more than anything else. And I feel pretty good about the state of our state courts in this state.
John, anything to add?
No, I was actually going to ask you, I mean, from your question, ask you. I've been struck of late with the phrase, in good faith. And it feels to me that in good faith has sort of left the arena right now. And that's really an important part of the law, isn't it? I mean, I'm asking this as somebody who doesn't know. I mean,
it's so fragile. You know, it's all. I mean, right? It only works as long as we all agree to allow it to work. I mean, there's nothing really at the end of the day to enforce it. So, bringing credibility to government is really, really critical right now. And I feel like I have to keep doing what I'm doing right now.
You know, every once in a while, I think it turns out that the route to optimism lies through an even deeper cynicism. And let's be realistic about this. This is not the first time that there are serious signs within this country of corruption. Today is Fred Korematsu Day. This is the day in which we mark one of the Supreme Court's most horrific decisions that allowed the internment of Japanese Americans, and without a shred of evidence that they had done anything wrong, that they had committed an act of espionage. One of the generals who was in charge of the internment, when asked why we were imprisoning people who hadn't done anything wrong, said the very fact that we have detected no espionage by the Japanese shows just how clever they are in how they have done it. Now, if this sounds familiar, it's because we are human beings. We have always been fragile, we've always been irrational, we've always done stupid, self-destructive stuff. We look back at Salem in 1692 and we say, how can those 19 people have been executed? There were 300 years of killing people for being witches in Europe before that. In Germany, on single days, 130, 140 people were executed. There's nothing particularly novel about this time. You know, this is another horrible period that we have to live through and work our way through. And, suck it up and do it, right? That's what we do. We do what we can do. You work on the program to the degree you can. You work on your theater to the degree that that's a way to convey truth to people. But at the end of the day, all we've got is our capacity to fight. Because the cavalry is not coming. It's up to us to fight the fight and try and get it right.
Thank you.
Are you running for something?
No, okay. I'm running from a lot of things, but not for anything.
Hi, my question was for Mr. de Lancie. Did you find it hard to stay true to yourself while being an actor and not lose your identity while playing the characters?
I didn't hear quite all of it. Did I lose myself for what?
Did you find it hard to stay true to yourself while being an actor and not lose your identity while playing characters?
Well, sort of a twofold question. Losing myself, I'm going to assume that means doing work that I would prefer not to be doing, is perhaps, in shows that I would not like to be in, things like that. I was fortunate enough to be aware of that. I also, there isn't an actor that I know of that doesn't think that their last job is in fact their last job. And I had a family and children to put through schools and what have you. So there are times that I did jobs that I kind of don't. Well, to this day, somebody will come up to me and says, "Well, really loved you in blah, blah, blah." And I go, I have no recollection of that whatsoever. And so it's perhaps you're also talking about losing oneself as an actor. You can become more and more involved during the performances, especially during the performances, and roles can be sort of more suited to you, and you can fill that role. I mean, one of the things about acting is that you have to bring yourself to the role. Otherwise, somebody else could play the role. If you don't bring yourself to it, which is sometimes thought of as losing yourself in the role, then that's perhaps not as good a role for you or what have you. But the notion, that kind of urban, or not urban, but that myth that we lose ourselves. Only people who are psychotic lose themselves. I mean, we know what we're doing, and we allow ourselves to go there more and more and more. But it's all part of a technique, and it's all part of just working. It's what our job is. So I've never lost myself to the extent of not knowing what's going on or anything. Yeah.
Is there a question?
Yes, this question is to Mr. McCragy, the actor, and Mr. I think it's Hensdorf, the lawyer. It seems to me that there are a couple of things that you have in common. The actor is relating to a character, the lawyer to a client, and in telling your story, you each have a theme. It's apparent with the lawyer, because I've been coached by lawyers in a case, a couple of them, and they talk about maintaining a theme. That is, the lawyer lets the client know what the theme is, and that the client's not supposed to forget about it. The story that the actor's acting in also has a theme, although that might not be the particular responsibility of that character he's acting. But could each of you explain how you deal with, say, the theme of the story or character, and also the motivation? That is, are there things in common that involve character motivation for the actor and for the lawyer?
Well, actually, to pull off of what the question was there, I played a character a while back, just to give you an example. I played a character called Hans Biebau. Biebau was ran the ghetto of Lodz on the German Nazi side. I dealt with a man, Rumkowski, who was the mayor of Lodz. And I wanted desperately to be the best war producer of uniforms and blankets for the German army, and Rumkowski wanted to save his people. Into this story comes the final solution. Now we have a conflict which we both share. And then the dialogue becomes, in this play, Rumkowski on that side, me on this side, and we are negotiating. We've got to get, the order is 3,500 people on the trains on Friday. And I'm saying, look, give me the children who are under 10. They are not producing blankets. That will keep you with the adults, and we're playing numbers. And the audience is crying. So it's very intense stuff. I had a difficulty being able to go from who I am to playing somebody like that. Because I'm like, whoa, whoa, whoa. So, and I'm searching for the character. And I'm also searching for a way in, which I hope somewhat explains your and it came to me in the most unusual spot. After the first week of rehearsal, I'm going, man, it's not coming. Why am I not? It's just not coming. I can feel it. I'm standing in line, and a guy for lunch, and a guy's buying a soda. And he pulls out the money to buy the soda and a $5 bill fell on the floor. And I reached down and I said, "Oh, excuse me, you've dropped your $5 bill. Thank you very much." And as I'm walking back to rehearsal, I went, ooh, I had another choice. I could have stepped forward and with my foot covered that $5 bill. Where would that have taken me as this character of Bebow? Is it possible that Bebow, when he was that age, many years before, had stepped forward and covered that $5 bill? No one would have known. It would have been my little secret, and it would set me off. And that was something that helped me get into, I went, oh, now I understand. I'm not playing a monster. I'm just playing a guy who needs to get people on a train. Very simple. There's the authenticity of it. I'm not playing this. I'm playing, we got a logistical problem.
A small-time crook.
Yeah.
Years ago, I had I was still a relatively new lawyer. I had a client who was the most nervous client I've ever had in my life. He made a decision. He worked for a business. He had married the boss's daughter, and he'd made a decision that had gotten the company sued, and he could see his whole life flashing before his eyes. So the other side is taking his deposition, and the first question is, "What's your name?" And he said, "John Smith." "Where do you live?" "Oakland County." So we did about 6 questions like this, and the lawyer on the other side knew me, and he looked at me like this, and I said, "Give me a minute." I took him out in the hall, and I said, "What's going on?" And he said, "Well, you know how you told me to pause after every question?" He said, I'm counting to 50. And I said, "Count to 1, and we'll be good." But what I realized was he was afraid. And what I've come to realize pretty much about everybody who connects with the legal system is they're afraid. And so I think your job as a lawyer is very, very similar to what you just described. You're trying to figure out what the narrative is and what the facts are and what things can be said, but you're also trying to figure out, you're trying to get into the heart of your client and say, what are they experiencing? What's making them nervous? What's scaring them about this? And we're very hard on lawyers right now, and for good reason. Lawyers are doing lots of terrible things at the moment. But I want to suggest that if we're looking for more civility in the world, going around and looking at people and saying, what's their story and what are they afraid of? You could do a lot worse than that. It is 7 o'clock, and I have been ordered to pull a hard stop at 7 o'clock. Will you please join me in thanking John and Bridget for being here? And you have been a fabulous audience. Thank you so much. Please give yourselves a hand as well.